Laws govern everyday life. The legal system exists to provide justice to everyone. Attorneys are there to serve. If bankruptcy looms, if the police come knocking on your door, if your constitutional rights have been violated, or if you or a loved one have been injured through no fault of your own, we depend on them to defend our rights. Many are intimidated by the complexities of the law. Our mission is to help you navigate the legal system, to provide you with news you can use on Talking Law TV.
And welcome to another edition of Talking Law TV. I'm your host, Michael Shortt. Tonight we're going to talk with Doug Andrews about juvenile court and deprivation actions. Gene Brooks will tell us about the vaccine decision, and Jeff Harris will tell us about dangerous premises. So stay tuned. You're going to learn a lot tonight.
Who defends the Constitution when somebody challenges its authority? For more than 200 years, our courts and the judges, juries, and lawyers who serve justice every day have protected American freedoms by upholding the Constitution as the highest law in the land. America won't work without fair and impartial courts. State Bar of Georgia. Lawyers dedicated to the Constitution's promise of justice for all.
Leave your legal question for us on our toll-free law line at 888-203-7LAW.
And we're back with Talking Law TV, and we're here tonight with Doug Andrews.
Michael.
First batter up.
Let's go for it.
And we're talking about juvenile court and something called a deprivation action.
It's there.
What is it?
For the unwary.
Unwary.
Well, a deprivation action is designed to protect the interests of a child. If the child is without proper parental care, supervision, control, if the welfare authorities have to step in, they do so under the provisions for a deprivation action. The child's being deprived.
And what, we're talking all ages?
Yes, up to age 16.
Okay, and who can file this motion?
Well, generally it's done by Child Welfare, Department of Family and Children's Services, the Child Protective Services. May get a call from a neighbor concerned about somebody beating the heck out of a kid or starving a kid or a child running loose at all hours of the day and night. Whatever it is, the child is not being properly cared for. Usually it is triggered by a police report or somebody calling one of the hotlines for Child Protective Services, and they intervene then. If they come out and check it out, if they think the child is at risk, they will snatch the child out of the home and put the child in emergency protective care. They can hold that child for 7 days until they sort things out.
Now, what are the guidelines? Because I know when I was young, my mother was divorced and we were latchkey kids. Old standards, new times. Could she have gotten in trouble nowadays if we'd have come home in the second grade and let ourselves in?
Latchkey kids are interesting. Generally, if the child is old enough to walk home from school alone, the child, in my opinion at least, and maybe the courts, is able to stay at home for a few hours alone. But if the child is being left alone all night, that could be a problem. But usually we see those issues come at preschool age, younger children. Mom may lock the kid in the house or in the bedroom and go to work with 3- and 4-year-olds. Well, that's not good, and that would not be proper parental care and supervision.
Does a person, now, as far as needing an attorney, do you need an attorney to defend yourself or to get your kids back, or all of the above?
Let me answer it this way. The state is going to have an attorney trying to take your kids from you or place the child somewhere, so you had best have an attorney to help you present your case, present your facts. The reality is that they cannot find the child is deprived because of financial hardship of the parents. Just because parents are poor and can't nutritionally feed their kids the way that somebody else could, that they're eating oatmeal every day, that's not going to be a basis for deprivation if it's due to financial circumstances of the parties. The poor don't live as well as the rich, but it is more of what is the effect upon that child's health, welfare, and emotional condition.
So mom goes out to party, big trouble. Mom just doesn't have any money, not so big trouble.
That's, I think, a fair statement. But let me answer that other point. There is little known, there's a private deprivation action. Normally we see it where Department of Family and Children's Services will intervene to protect a child, but grandma or an aunt or uncle, somebody sees a kid's being abused or not being taken care of properly, they can bring an action, a private deprivation action. They can, and they should get a lawyer. That'll be the way to go because the lawyer will know how to do it. They will file a petition alleging specific facts of why that child is being deprived of that proper parental care. So it doesn't have to be social services getting involved. It can be a private action. And I've had a couple of cases where grandma has intervened because her own child has not taken good care of the kid.
Oh, you mentioned a moment ago about punishment of the kids. I mean, when again, my own example, I mean, I've heard go get me a switch many times. Nowadays, you go get a switch, someone's going to call protective services. Well,
and that may well be. If you smack your kid in public, you can expect the whole store to be down on you and call the cops. And, well, corporal punishment of your child is still not a crime in Georgia. And I have prosecuted a time or two parents who were charged with battery of their own child, and that is a real easy line for me to draw. If the child needs medical care, you're over the line. But I don't suggest you use a hairbrush. I don't suggest you use a coat hanger. I don't suggest you use an extension cord to beat your child. Smack them with the open palm of your hand so it hurts you as it hurts them. And you'll be all right.
Yeah. Well,
unless you give them 50 licks and you inflict such pain that it causes, and what happens if you smack the child's bottom too many times, the blood comes to the surface, and you can seriously harm that child, and kids have died from it.
And there's no joke to be made about, I mean, there's tough love and there's abuse.
That's right.
I mean, because in the case of tough love, it should hurt you more than it hurts the child.
Right. But if you're smacking your kid more than 3 times, I think it's more than necessary. If you haven't got the message across to the child by that point, it's not working.
But clearly, you know, the last generation of timeout didn't work either.
No,
that's ridiculous.
Thank you, Dr. Spock.
You're welcome. We try to offer everything on this show, especially with your topics.
There you go.
Parental rights can be terminated in deprivation acts.
They can lead to termination. In a deprivation action, the concern and foremost goal is to do what's best for the child. And usually, hopefully, that means reunify the child with the parents, because we do honor a parent's rights to raise their child, and we don't want to sever that relationship except for very good cause. So that a deprivation action's goal should be to, hey, that's not the way to raise a child. They develop what's called a permanent placement plan to reunify that child with the parents. Maybe they need some education, maybe they need some social services, but the goal is to put the child back in that home if they can do so safely. If, from further investigation, they say, mom's a chronic meth addict and she needs serious treatment, then if it's a repeat kind of affair, they may then initiate termination of the parental rights based upon that deprivation.
When can mom or dad be put in jail?
When they have physically or mentally harmed that child. It is also a criminal offense, or can be. But usually that requires reckless and gross conduct if it's through negligence, or an intentional act if they did it on purpose.
And does the child, would he have legal representation to find him the best possible care, or do relatives step up, or the state makes all those decisions?
In a deprivation action, they will have a guardian ad litem appointed to look after the interests of the child. In the criminal process, they do have, the DA's office, District Attorney's Office does have a victim witness assistance program that can provide some guidance for the child.
Okay, well, thank you, Doug. We appreciate it. If you have a need, please look up Doug's information on our website, talkinglawtv.com. We'll be back with Gene Brooks talking about the vaccine decision right after this.